involving law enforcement within Maricopa County, as well as all in-custody deaths involving law enforcement within Maricopa County. But the focus today is going to be on officer-involved shooting incidents and the role of the office within that. And the purpose for my office's involvement and why we have a specific protocol for reviewing officer-involved shootings is several-fold. First, we want to be able to ensure a professional and impartial investigation. Next, we want to promote a thorough completion of the criminal investigation, and we want to ensure due process protections for all involved. We don't jump to conclusions or make assumptions regarding the underlying circumstances as they may initially present themselves, and that works for both the suspect slash person who may have been injured as a result of use of force, as well as any given law enforcement personnel who may be involved. And then we also want to make sure that we can maintain the trust of the community, which precludes rubber stamping any law enforcement investigation. No one is above the law, no one is beneath the law. In fact, going back to 2002, there have been 3 police officers charged with criminal conduct related to use of force incidents. Back in 2002, the Chandler police officer, Lovelace, who was charged and tried, and he was acquitted by a jury. There was a Tolleson police officer in 2005, Officer Ken Hernandez, who was convicted of a felony for a shooting, and then obviously from a 2010 incident, the most recent one, former Phoenix police officer Richard Chrisman, who was tried and convicted. Last year, and year to date, we've indicted or charged via direct complaint 13 different sworn law enforcement officers for a wide variety of offenses. And we don't hesitate to file criminal charges where the evidence calls for us to prosecute. It's not a mechanical analysis, but where we need to, we do so. Now, with respect to our use of force protocol, whenever there's an officer-involved shooting, an on-call prosecutor responds to the scene to begin implementing that protocol. The person who is usually called to respond, unless a backup is involved, is the office's law enforcement liaison. And we have the benefit of our law enforcement liaison being an NRA certified instructor and a graduate of Gunsight that includes training in tactics, and also happens to be a competitive shooter. So we have a degree of subject matter expertise on the prosecution side that can be brought to bear in looking at scenes and conducting walkthroughs and reviewing the evidence and what's being said about what happened. And what I can tell you too is that in each of those 3 instances that I referenced earlier, where there were charges brought for use of force incidents, prosecutors on scene noted that the scene evidence and what they were being told didn't quite add up and caused concerns that later led to charges being filed. Now, when the deputy county attorney gets on scene, and law enforcement agencies have been trained on what to expect from the office when we get there and what needs to be seen as well. And first and foremost, there's an initial briefing in order to go over what happened up to that point. The personnel who've been involved in the shooting are segregated and they're separated. They obviously can have access to a union representative or to a defense attorney who may come to the scene just as part of whatever the procedures are for their respective law enforcement association. But they're not present for the initial briefing on, again, the circumstances leading up to what may have occurred that resulted in a use of force. The officers then, either individually, if it's one officer involved, or multiple officers, are at different points in time asked to provide a statement and conduct a walkthrough of the scene to go over what they saw, decisions that they made, up to and including a decision to use force. Then Evidence there at the scene is reviewed, in particular where shell casings might be, various angles for observation, where shots were fired, location of other individuals, everything done to get an understanding at that point in time of what was going on when force was used and what did the officer believe was happening that resulted in that particular decision. With respect to the employees, though, if they were involved in the shooting, they're also not given access to any other witnesses, fellow citizens who might be in the area. Obviously, the goal and intent there is to be able to get independent recollections of what happened. Now, having said that, too, what you need to understand is if you're involved in a shooting incident or something like that, perceptions and trying to go back in time and recall right then and there what happened can sometimes be a problem for folks. The walkthrough itself helps in understanding what those perceptions were and why particular decisions were made. And then, I'm jumping ahead a bit, but you then need to take into account everybody's ability to perceive where they were at, what they saw, what they heard. Invariably, folks who have little experience with firearms will report hearing many more shots fired than actually were fired, either because of any echoes or just hearing a number of shots and thinking that it was a lot more than what actually occurred. The walkthrough itself will consist of the case agent, the person on scene who's responsible for the investigation, as well as the officer who is in control of the crime scene, any crime scene technicians who may be on hand, the deputy county attorney who's been called out, sometimes the defense attorney will be on hand, and then the officer who was involved in the use of force. Now, I'm going to tell you, and I'm going to underscore this in particular for the people of Maricopa County, that when we go through and do this, almost without exception, I think the Chrisman incident might be one where the officer did not do a walkthrough, but in every other instance, officers are conducting the walkthrough. They're cooperative with our attempt at that point to establish a baseline for what appears to have happened, what people think might have happened, and the decisions that were made, and all of the factors that went into that. That's important for us as prosecutors because any subsequent investigation that we then receive from the investigating agency, whether they're from the same agency as the officer who used force or another, to then compare and contrast to make sure that details that were observed by a deputy county attorney are reflected in subsequent analysis, and areas where we may have identified additional follow-up is going to be necessary to answer questions at that scene, in fact, were done. After that initial walkthrough then, it's our practice to have an initial review within the office, which ordinarily involves whoever the responding deputy county attorney was, briefing me on what the initial review of the scene looked like, if there were any questions or any issues that appeared to be present. And then we let the criminal investigation take its course, and then it will come into the office for us to review for a potential criminal charge. The criminal review that we do is in many ways no different than how we would review other submittals from law enforcement requesting a charge. The difference here is that whenever there's an officer-involved shooting, there's an automatic submittal that comes from law enforcement. We expect that to come to us for a review. There may be other situations involving other types of crimes where police department can go through and conduct an investigation, a detective reviews it, and then decides that, well, there's not enough there to request this office to review for possible charging, and they may make an internal decision consistent with their own policies in any given agency and not submit it. That's not the case with officer-involved shootings or use of force situations. All of those are expected to be submitted for us to review. Again, that gets back to wanting to be able to maintain trust in the community for the law enforcement officers who have been delegated the authority that they have by citizens within the community, and to make sure that our interactions with law enforcement are ones that we can maintain confidence in. as a quick aside, I'll remind you that we are required to turn over information to the defendant in criminal cases where there may be questions about the officer's professional competency, honesty, or anything that may suggest issues that could come up to impeach an officer's testimony in any criminal prosecution. We now refer to that as the Rule 15 disclosure database because it involves more than simply instances in which someone's integrity may be questioned. So as prosecutors, we understand that we're the ones who will initially see the results of law enforcement conduct, whether that's with respect to interactions with suspects in cases that are forwarded for review for charging and then for prosecution, because we're the ones who put that testimony on for juries to consider. So we've got to review it there. And if there are issues with how law enforcement is conducting their professional jobs, we need to know in order to fairly assess whether or not there are cases that we can bring and have juries consider. In this particular incident, or instance too, where we're talking about officer-involved shootings, we want to make sure that the use of force is appropriate. The degree to which the community maintains trust and confidence in law enforcement also goes a long way in having people willing to assist with criminal prosecutions, report crimes, be witnesses to crimes, and in particular too, if you're a victim of a crime, having confidence that you can report an offense and then it's going to be thoroughly investigated and that justice is going to be done. Before going through the next couple of slides to show you the statutes that we review in order to assess whether or not a law enforcement officer or a deputy's actions are justified under Arizona state law, I do want to share with you some statistics over the last several years of officer-involved shootings. Going back to 2011, we had a total of 43 officer-involved shootings. Out of those 43, in 42 of them, the suspect had a weapon. And the weapon may not necessarily have been a handgun. I don't have that degree of a breakdown here for you. It could have been something that could be used as a weapon. Everything from a tire iron, rebar, a baseball bat, all that could fall under that particular heading, in addition to a handgun or a rifle or a knife. In 2012, we had 46, and out of that, there were 39 instances where the suspect had a weapon. I don't know if I gave you the raw number. It was 42 out of 43 in 2011 where the suspect had a weapon. 39 out of 46 in 2012. In 2013, 44 out of 49. And so far to date in 2014, and if I include the most recent officer-involved shooting incident from this weekend, 24 out of 30, or 24 out of 31 have had a weapon. Additional factors too, if we go back to 2011, and the following is also dependent upon the information either provided by someone who called in the incident or reported something going on, or during the criminal investigation was additional information that law enforcement became aware of. In 2011, there was one circumstance where law enforcement was aware that the suspect or individual who was the subject of use of force had mental illness or a mental health related situation. In 2012, we didn't have any where there was a report of a mental health situation. In 2013, 10 out of 49, roughly 20%, there was mental health or a mental illness involved, or was a component of the suspect or subject. And then so far this year, and if we include, again, the shooting that occurred within the last week, not this weekend, that's the first one that the office is aware of directly where there's evidence of a mental health component. With respect to drug-related component, there were 24 out of 43 in 2011, 29 out of 46 in 2012, 30 out of 49 in 2013. And so far out of the submittals to the office that we've reviewed, we've had 3 out of 7. When I say submitted to the office for review, that's where the criminal investigation has been complete and we've been able to review it. I mentioned that because oftentimes someone who may be under the influence could also appear to have a mental health issue, but the effect of that can be very different in how the officer is able to interact with somebody, and that can certainly influence the dynamic of what's going on. And if the officer doesn't know that information ahead of time, then they're dealing with the situation as it presents itself. And most of that information about drug use will come afterwards during the criminal investigation and a toxicology screen that's done by the ME. So, in reviewing officer-involved shootings, these are the statutes that we take a look at, and it's essentially the justification chapter within Title 13, our criminal statutes. I'm going to go through these real quick with you, and then I'm going to go back and highlight a few of them because there's a common component to reviewing all of these cases and trying to determine whether or not we have the evidence to bring a criminal charge. And you see the initial ones here, it deals with justification and the use of force under particular circumstances as well. Defense of a third person would be implicated in those instances in which multiple officers are on scene, and the general scenario is in which a suspect will pull a weapon focusing on one particular officer where another one has the opportunity to use force and to fire on the suspect. If that first officer would be justified in using deadly physical force to defend himself, that other officer then is equally justified under our law to use deadly physical force. Duress doesn't really apply. I threw that up there so you could see that this is the entirety of these statutes. So I'm wondering which one did I leave out. And then of course, use of force in crime prevention. I'll touch on that. But again, most of this is use of physical force within specific contexts. And we can give you a list of all of those too that are regularly reviewed. And so the officer-involved shooting committee will convene. If you add up the collective experience of the prosecutors who conduct the review in order to make a recommendation, we're talking easily in excess of 100, maybe a couple hundred years worth of collective prosecution experience, along with the opportunity to have some subject matter expertise play a role too with the background I gave you for a law enforcement liaison. My chief deputy himself is a former police officer from the city of Tucson, so there's also an understanding of the degree of training that may be involved. Although I want to caution you at this point too, when we review a case, our review is for whether or not there is evidence of criminal conduct. In other words, if there's evidence that does not support a conclusion that the officer was justified in using force, we're not reviewing to determine whether or not any particular agency's policies were followed or whether or not specific training was relied on in making a decision to use force. Those reviews are separate and apart. They can be part of an internal police department's internal affairs investigation and review, or a general policy review, or a subsequent review by Arizona Post's Peace Officer Standards and Training Board for Arizona to assess the nature of training that's been provided and whether or not that's sufficient. Again, I'll be talking more about that on Wednesday in terms of the mental health context. But those reviews, policy and training, that's not part of what we're looking at. We're looking at whether or not the evidence presented from our walkthrough and the subsequent criminal investigation allows us to either determine that the use of force was justified under Arizona law, or if it wasn't justified, what criminal charges should be brought. And the additional statutes then to share with you, when we look at them, there is a commonality among them all, and that is whether or not the police officer within that particular situation conducted themselves in a way that a reasonable person who was in that situation would have. And again, that's where our focus then is on what was happening at the time that a police officer made a decision to shoot. Other circumstances may play into why they got to that point, but the focus is going to be on whether or not the circumstances at that particular time permitted the officer to use that level of force. And in the overwhelming number of cases that we take a look at, and I mentioned the 3 instances though where things did not add up and we were able to bring a charge, the decisions that are made at that point in time permit an officer to use force up to and including deadly physical force, shooting, under Arizona law. And as I mentioned earlier too, in the overwhelming number of instances, we've got suspects who have weapons too. And the threat that they present to the officer or to the community is a factor that must be considered in assessing whether or not the use of force was justified. It's also important to keep in mind too that the degree to which a police officer believes use of force is necessary doesn't occur without a context either. If you go back to November 22nd of 2010, when I took office, to provide specific context here, we've had 5 sworn law enforcement officers and or deputies who've been killed due to gunfire. There are several others who have also been killed due to vehicular assaults, but focusing on the gunfire aspect, it is a very real threat for law enforcement out in the community. And the danger in second guessing or engaging in pure hindsight analysis about what would have been a better tactical option is creating circumstances where a law enforcement officer may think twice or 3 times about what should they do in that split-second moment. They may not just have consequences for themselves, but potentially for other law enforcement officers and other members of the community. And there have been a number of instances over the last few years too where suspects who were shot actively shooting themselves represented an immediate threat to other members of the community. So again, before taking your questions, I want to underscore again that we're looking at potential criminal conduct and whether or not under Arizona law, in general with all the statutes that I shared with you, would a reasonable person in that police officer situation facing what they faced have engaged in using force. The most recent officer-involved shooting prior to this weekend, that again will be the subject of discussing the mental health component of it, was a tragic incident for everyone in the community. And the decision for the Phoenix Police Department to have the Department of Public Safety conduct a criminal investigation is a decision that any agency can make. I've got no quarrel with that at all. We'll conduct the same kind of independent review of the Department of Public Safety's investigation as we would have done with the City of Phoenix. There's nothing in the initial walkthrough that we saw that would have suggested that Phoenix either did not have the capacity or the competence to have conducted a thorough criminal investigation. But I'm not the head of that agency, and the decisions that are made to have another agency review a particular shooting is up to that department, and again, that's fine. We'll review the investigation that comes in from anybody else in a similar way. And in that sense too, I want to underscore that my office's statement about not treating the most recent shooting differently than any other one was to underscore that we take them all seriously. And that while the mental health circumstance here does make this one particularly tragic, the underlying facts and what we've seen so far did not suggest that anyone was hiding evidence, mischaracterizing what occurred, or not providing all the information that the Deputy County Attorney on scene saw was available. So I want to underscore that too. And again, to restate it, my office conducts an independent review of every criminal investigation in an officer-involved shooting. We would have done the same in this case for the Phoenix Police Department. We'll do the same thing with the Department of Public Safety. And over the history of this office, again, we haven't hesitated to file charges where the use of force was not justified. And I'd also reference multiple instances in which we filed charges against detention officers for assaulting inmates here within the county. The last point I want to make is, and this is sort of, I guess, I won't say it's readily apparent. One of the other reasons for taking the time here to go through all of this with you is to then be able to answer the question of whether or not Phoenix could be like Ferguson, Missouri. The short answer is no. The relationship between law enforcement and the community in the Phoenix metro area and throughout Maricopa County is a very strong one. This office on an annual basis engages in hundreds of different community-related events, whether it is going out to neighborhood pools with our Safe Kids Summer program, our Friday Night Football Patrol, which incidentally is starting up relatively soon, or any other crime prevention training that we put on for folks to avoid being victims of crime, to the numerous speaker bureau events that deputy county attorneys go to, as well as all the different community events that I participate in, interactions between community groups, the relationship that we have with a number of different community organizations. We're embedded in this community. We're not strangers. People of Maricopa County do not come across prosecutors just in the courtroom. And I think the same can be said for the police departments throughout the county too, and their community outreach programs. I've seen it firsthand, certainly in Phoenix, and participating in community forums with city council members and a whole host of other opportunities to be involved in community events. So police officers aren't strangers either to the fellow citizens that they're serving. And lastly, what I can say as the elected county attorney to the people of Maricopa County is that when it comes to these sorts of situations, we're going to do the right thing because I'm not afraid of the truth, whatever that may be. If an investigation reveals that a police officer has done something improper, they'll be charged. It's not a happy occasion, but it's certainly one that is necessary for people of this community to maintain trust and confidence in the law enforcement authorities who are working on their behalf to keep the public safe. And it's also a core responsibility of prosecutors too. So that's the specifics that I wanted to share, and I'll take your questions. To the extent that there are particular cases or situations that you want to discuss, if I'm familiar with it, I'll answer the question as best I can, but if not, I'll just tell you in advance we'll have to get back to you on that. Questions?
You did bring up the Ferguson thing, and I know there's an expert working with New Mexico right now who says the number of officer-involved shootings we've had just this year alone are red flags, and does feel that it could potentially blow up at any time.
Well, I think that's irresponsible because you can't just look at a raw number and try to deduce from that. And that's a particular expert that I will outright repudiate. It's irresponsible to make a statement like that. We have a very unique criminal environment within Maricopa County with the number of folks moving here, the criminal environment that we have to deal with, and you've got to look at each one of the circumstances involved to try to determine what went on there. You can't make a categorical statement like that. That's somebody I would look forward to cross-examining at trial.
Bill, good morning.
Hi.
You mentioned, you take a snapshot of the time just for justification. It's not really just the events leading up to it.
Correct.
In this most recent case with mental health patient, whether people know it or not, it seems like they're more concerned with did they have to go through that process to get to where they were. And if the facts are as we know them, you know, a claw hammer a foot away from an officer's head on the surface seems justifying. Do you think that, I can't remember in my memory, any time PPD has given an OIS to another agency. Do you think the climate of what's going on, the Ferguson, the number of officer-involved shootings, do you think that had a decision from Chief giving this to somebody else?
I won't presume to know all the details that was discussed within the Phoenix Police Department to come up with that decision. But again, I would say that any agency can ask another agency to step in and investigate. and it doesn't necessarily raise any red flags in that regard either. They could have no reason, they could have any reason. It's really up to the accepting agency if they're going to do it or not. And we have had, this is different, but we have had other shootings where the agency responding just didn't have the resources or depending on what the situation was, the expertise to handle what may have been a unique issue. So, I mean, those are some of the more objective, easy ones to see. In this particular instance, you know, the Phoenix Police Department believed that at the end of the day, in order for everyone involved to have a fair review, that they wanted to ask an outside agency to do it. That's up to them, and again, I wouldn't quarrel with it. Our review, it will still be the same for us to carry out our responsibility regardless.
You're also very clear that you do review every OIS, and there's no doubt about it. How often does that review constitute investigations by your investigators? It seems in my experience that your review is based on the report as handed to you by the agency doing the investigation. So you're actually reviewing the agency's investigation. You're not doing your own investigation. And so your review can only be as good as the investigation is. So how often do you have your investigators do additional investigation, conduct your own interviews, witness statements, ask for a piece of evidence to be tested that might not have been tested by the agency?
Well, again, that's what's important for us going out and doing that initial walkthrough too, because that gives us a context then for looking at that subsequent investigation. Again, I want to underscore this. You know, when our deputy county attorneys go out to that scene and they're looking at what we've got there and they're going through the walkthrough with the officer, that gives us the opportunity at that point to provide a baseline understanding of what happened, so that, again, if there are facts or circumstances that aren't developed that we want to see, our first response is going to be going back to the criminal investigating agency and tell them there was additional information here we wanted to see or that we need to see. And, you know, I want to say that whenever that has come up, that the responsible agency is cooperated in getting us the additional information. We do have investigators within the office, but it's never been the practice of this office to try to conduct a parallel investigation at the same time. We've never had the resources for that, and we've never had a circumstance where we weren't able to get the information we were looking for with a cooperative agency. You know, I can tell you that if we ever had a circumstance where we seriously questioned the competency of the investigation or the integrity of the information provided, I wouldn't hesitate to either have our own investigators go out and do it, because our investigations division now is very different than what it used to be too. We actually have them trained to a level consistent with their status as sworn officers, and we are using them in a complementary investigative capacity for other areas that we prosecute. If I thought we needed to do that, I would do it without hesitation. Or if we saw that there was going to be an issue, again, at that initial walkthrough showing up where things just weren't looking right, you know, we can ask at that point in time to have the agency involved request another agency come in and investigate it.
Just so I understand, are you saying that when you do have questions that your deputy county attorney is in contact with that agency as their investigation is going on and saying, well, did you do this, did you do that, or once you get it for review? Well, you know that I've covered an ADOT officer, Joe McKenzie, his shooting death of Plant Park stuff, his neighbor. And the allegation there was that the neighbor threw a thing of gasoline on the officer.
Or tried to.
Yes. Well, and that's a key point, because that agency that did the investigation, which was PPD, even though it was an ADOT officer, because it was in PD's jurisdiction.
Well, and that's one where I would say that ADOT does not have the capacity or necessarily the capability of investigating.
The shooting happened in Phoenix. So those clothes were never tested for gasoline. There were never dirt samples taken to test for gasoline where the alleged gas was taken. And you're talking about not jumping to assumptions and accusations. The detective that was on the scene that was assigned to this case, 3.5 hours afterward, called the victim's sister and said he threw gasoline on the officer. That was off duty. The officer was off duty, and the officer had to shoot him in self-defense. That's 3 hours after the shooting, before the investigation is even complete. The detective detective, the homicide detective, is making an assumption that it was self-defense when it goes on to say the officer shot in self-defense and as a result your son died.
But and when I'm talking about assumptions, I'm talking about what my office is going to be responsible for.
Right, I get that. And so this detective who made assumptions then writes her report and turns it over to you. That's all you get to base your decision on, is what she's done. You know? So my question is, at what point did you get your investigators to say, something's not ringing true here? The clothes weren't tested for gasoline. The officer's background, his background was rifled with integrity issues and with overstepping his bounds as an ADOC officer, as a deputy constable. I mean, it was rifled with integrity problems that never show up in the report. Again, you get to review.
No, and what we got to review, there was information in there, not just about some of those other incidents, but also the polygraphs that he underwent. And again, which, well, we wouldn't say failed, we would say that there were signs of deception. And all that gets taken into account too in trying to assess whether or not we've got evidence that we can bring against someone for a criminal charge. All that information that you outlined there, all that goes into ultimately a decision that was made to terminate him from his employment. All that could go into assessing whether or not a civil wrongful death suit would be appropriate against the individual. But the focus here is a very narrow one about whether or not everything that we see, because there were other officers who showed up on scene and made statements that they could smell gasoline. Well, if you can smell it, I don't know if necessarily then conducting a test on the clothing would make a difference one way or the other. You know, if it didn't get on the clothing and you still had it on the ground, or you still had it in the surrounding area, that's still enough then to substantiate an initial allegation of what had happened. It's not necessarily conclusive either. Everything else would need to be taken into account. But as I recall too, the individual who was shot there was wearing rubber gloves, had matches with him, matches that were found on the ground, was wearing a mask. So there are other things there that can independently serve to determine whether or not what we're being told happened. Well, if we think it didn't happen, can we disprove that and then bring a criminal charge? And in that particular instance, you know, the decision was that we're not going to be able to bring a charge here. Keep in mind too that even in those circumstances where I say that we're not going to bring a criminal charge is different than saying that, yeah, this was on all four square corners a Gold Star shooting. Two very different things, because again, our focus here is on the criminal conduct aspect. It's got nothing to do with whether or not someone was acting outside the scope of their authority granted to them by their employer. In the particular instance that you're talking about, you know, we review it as a regular self-defense scenario then, and somebody's you know, status, even though they were an ADOT employee as a sworn officer, that's not going to help them.
No, and the detective made clear in her report that she treated this as one of their own. They rearmed him at the scene. They rearmed him, which is Phoenix police policy. Not to mention the title of the report was aggravated assault on a police officer, as opposed to homicide. It's my experience that OISs are homicides, whether they're justified or not, they're homicides. Yeah,
but we don't rely on that alone. We're going to take a look at everything separate and apart from that. So whatever a detective wants to put on the face sheet, that's not going to dictate what our ultimate conclusion is going to be. It doesn't matter. So again, for the initial question you were asking me, that's why our call out is important and why we have a specific protocol that all police departments within Maricopa County follow. That protocol is even communicated to state agencies. They follow it when they're here. Federal agencies are aware of the protocol, although from time to time we'll have a separate issue with them. And being federal agents, we've got our own issues there. That's another press conference. But they all know what they're supposed to be doing. And so if there are also instances in which, you know, the responding deputy county attorney thinks the protocol is not being followed, there's going to be a conversation on that. And there's going to be an assessment of, well, what's going on here? Is this just a training issue? Do I need to look more carefully and ask, where are your civilian witnesses? What have they said? All of that gets taken into account. Your question also gives me the chance, too, to underscore that we're not just listening to what law enforcement is telling us. We're also asking, where are the shell casings? Show me. Where was the officer standing? Show me. It's not just getting on scene, getting a briefing, saying thank you very much, and walking away. No. The responding deputy county attorney walks through that scene, taking care not to disturb anything. Where are the casings? Where were people standing? Where is the weapon that the suspect supposedly had? They're looking at, for example, if suspect was shot inside of a vehicle, we're taking a look at the angle of the trajectory that a bullet took going through that windshield, and comparing and contrasting then when an officer is saying, I'm standing here, here's what I see, here's where I shoot. We're fortunate in that regard to have prosecutors who have got the level of training to be able to look at those things. And again, that then forms a basis for us to look at any subsequent criminal investigation. Look, if an investigating agency is going to try to tell us that a police officer was standing in front of a truck and fired at the driver, we're going to expect to see a particular trajectory there then. And if instead it's off on a side window, and I'm giving you an extreme example to illustrate the point, if it's off on the side, we know that's not right. We know that's not right. And that's then is going to drive us to do other things. But again, in my experience in responding to scenes as a vehicular crimes prosecutor, and in all the briefings that I get from our prosecutors who go out to scenes, these agencies are very sensitive to the perception the community has when someone has been involved in a shooting. They know they need to get it right, because the degree to which the community is going to have confidence in them is going to bear in large part on the quality of the information they're going to be providing to us to be able to make a determination whether or not that shooting was justified. And so it's a very serious review. We're not handicapped from a standpoint of the only information we're going to have is what we get from law enforcement because of that initial response and that walkthrough, and the ability, if we need it, to ask for additional questions and get more information later on. We don't bring in law enforcement at a point when we're looking for additional information and necessarily tell them, hey, here's where we think we're going to go, so we need you to go get this to either confirm or deny it. We may just say, we want to see additional information. We want you to do a follow-up on this civilian witness interview here. We want you to go back and talk to other citizens who were there in the community and see what they had to say. And what we then wind up having to do, and I've done it in a couple of cases where I get the report from the officer involved shooting committee and I'm going through and looking at it, and you can read one citizen witness statement who says, I never saw a gun. And then I ask the question, okay, so where was the gun? And you read later on in the report, a different citizen who was standing on the opposite side of the street saw the suspect running with it, but he had it held against the opposite leg of the first person who didn't see it. So we're able to take a look at everything there to try to assess what happened in order to make the decision.
Do you feel that Phoenix PD is being scrutinized because that shooting was on the heels of Ferguson? And I know I was at a rally where Reverend Moffitt was quick to say this is police brutality, but everybody was still on the scene. We were hearing in our earpieces that the shooting had happened, and everybody was on the scene, and they were on stage calling it police brutality.
Yeah, I'm not going to take his comments for much.
Do you feel that this is the reason this has taken such a high profile?
I think we can't ignore what's going on in terms of a national conversation right now. In fact, I think that goes to, again, the professionalism of our local police departments to be sensitive to that too. But that knee-jerk reaction to call it police brutality is completely irresponsible. And so, and even in Ferguson, with the days that have followed, there's been more information coming out about what had happened that again underscores an immediate knee-jerk reaction or assessment based upon circumstances before an investigation is done. There's always more to come. And I've always taken the point that, particularly as a prosecutor, you can't prejudge a case until the investigation is complete, because you don't know what other evidence might come along to take you in one direction or another. But within Maricopa County and certainly the city of Phoenix, look, I know that their chief takes professionalism in policing very seriously. I've seen him say it publicly. It's been underscored in all of my interactions with him between our two agencies. And, that kind of an attitude sets a very good tone for an agency and for the community of Phoenix. And, it's just very unfortunate where some folks, for their own personal aggrandizement, might try to take advantage of somebody else's tragedy, particularly during an election season, and try to create a narrative that they then get to be the hero in. So no, I don't see it that way at all. And again, and this is one reason why I want to keep the two aspects of that shooting separate, because the mental health context of it is what I think provides a very different level of a tragedy from the actual decision and the incident at the time that force was used. They're two very different things that have tragically occurred within the same event, but they each call for a very different response.
So do you have any sense as to whether PPD's policies when dealing with mentally ill are appropriate?
I think Chief Garcia has spoken to that, and I'm going to defer to his assessment there. I don't want to go much further because otherwise we're going to spend the next amount of time on a topic that I want to address on Wednesday. I want to address that separately because it's deserving of its own focus and conversation there.
Mr. Montgomery, I just wanted to ask one more thing regarding the investigation of involving the Quentin Barksdale 2013. There was an op-ed that was in the Republic this weekend from a retired senior police officer from Mesa that called that investigation, or rather called the review that the county attorney did on that investigation a rubber stamp. And some of the, in my own research, there have been other concerns beyond just the lack of the testing of the clothing and stuff that have been raised, including that this officer was implicated by the decedent in a robbery of his apartment a couple of weeks prior. So I wanted to bring it up because this appeared in the paper. As you mentioned, there is a higher level of scrutiny on law enforcement and prosecutors after something like this. What can you tell us about the review that you did on that and how thorough it was? Because there are people that really believe that it was not followed up appropriately by your office.
Yeah, and I know Bill well, and he's heard from me. One case does not make for a process or a policy of rubber stamping. And in that particular case, again, I mean, the point that you mentioned, yeah, there was a suggestion that Mr. Barksdale believed that the ADOT employee was part of that burglary. It just as easily goes to establishing motive for why he'd want to throw gasoline on him as anything else, which, again, when you're looking at the available evidence and reviewing the entirety of a particular case, there's always something more that could be done. The question is whether or not that's essential or necessary in order to be able to reach a particular decision. So, you want to go back and take a look at any previous case, even ones where we've taken them to trial and successfully convicted somebody. You can always find something and say, well, why didn't you do X, Y, or Z? What's important for us in conducting our review is taking a look at whether or not we have the evidence in order to be able to make a decision and reach a conclusion about whether to file a criminal charge. And a lot of the points that have been raised in that one particular case, they cut both ways.
The proceedings and the records from the review that you do, I can't recall the name of the committee, are those available publicly? Can you request them?
No, they're work product and they're used to help me make an ultimate decision too. However, all the police reports that are reviewed in that are all public record.
Right.
But when we sit down and look at it, we're making an assessment of a case and reaching particular legal conclusions and evidentiary assessments that is the the standard work of attorneys and particularly of prosecutors in that instance.
But it seems like a lot of these questions, and this will be my last question on this, but a lot of these questions and kind of suspicions that they raise in people's minds would be dispelled if you release those, that work product.
Yeah. Well, all the underlying police reports are available, and if anyone ever has a question about a particular decision that I've reached as the county attorney, that's always been subject for inquiry from not just the media that I talk to once every 2 weeks, but citizens out in the community. And I respond to them and will address their questions in detail the best that I can. So it's not as if we're making decisions involving use of force and then never talking about them again or being unwilling to address any of the other underlying facts and circumstances. I've been taking questions on Barksdale here. And so if there are other incidents out there that folks have a question about, they can ask and they'll get answered.
Bill, you're making it a point to continue to say we don't jump to conclusions. The investigation as it's going can go one way or the other. I know it wasn't your call because you weren't in office at the time, but if you were in office, would you have cuffed and arrested Chrisman on scene and booked him? Or do you think, knowing that he was a cop, know that he was going in where you would have waited for the evidence to shake out?
I don't know. I don't know. For the most part, if you're going to make an arrest on scene, just in general, it's because there's a concern over whether the suspect's going to be around. So I don't know. And even then, prosecutors don't get to tell law enforcement who to arrest. That's, it's the law enforcement officer's responsibility to determine whether or not they've got probable cause to make an arrest. We get in trouble as prosecutors if we direct an arrest because now we're outside of our lane. So what I could affirmatively tell you is that I never would have told anybody to arrest anyone. And whenever I've been asked by law enforcement if they have enough to make an arrest, what I usually say is, that's why you get paid your big bucks. That's your decision to make. I'll review it for charging when you get it to me. Any other questions? Okay, thank you for your time here.